Good evening. Welcome to our SIPAC webinar for this evening. We're very pleased to have very experienced expert presenters, first from the Howse Williams firm in Hong Kong, and then following that presentation, we'll have a presentation from our good friends in Indonesia, the S&T law firm. So first of all, I would like to introduce Paul Haswell, a partner with the Howse Williams law firm. Howse Williams is one of the top independent law firms in Hong Kong, and Paul is a longtime, highly regarded practitioner, particularly in the tech space. And Paul will be talking to us about AI regulation, not only in Hong Kong, but also trends around the world. And after Paul's presentation, then I'll make the introduction of our friends at S&T. So Paul, hand it over to you, and please share your slides.
Thank you very much. Hello, everybody. Great to be here. Let me just share these slides now. Hopefully you can see these. Can someone confirm that you can see them okay? I can see a nod.
Yes.
So that's good. Fabulous. Anyway, thank you very much for that kind introduction. So as introduced, I am a technology lawyer. I've been a technology lawyer here in Hong Kong for most of my career. I actually started as a tech lawyer way back in the dot-com crash. Remember that of the 2000s when everyone said that technology was going to go nowhere. And then I moved to Hong Kong in 2007. I've been here ever since, and I've seen a lot of real epoch-changing things happen. So I remember talking about the social media and how that was going to change the world, not necessarily in the way that I expected. And I would say that what we're seeing now with artificial intelligence is probably one of the biggest changes, probably even bigger than then, probably one of the biggest changes we're going to see to the way that we, not the way that we just do business and we operate in the technology sphere, but the way that we live, we'll probably see in any of our generations. And I don't think that's me over-egging the pudding in this one, to put it mildly. Now, to kick off, you're probably familiar with this phrase. You won't be replaced by AI, you'll be replaced by somebody using AI. Now, if you think about this, artificial intelligence as we have it today, so generative artificial intelligence, which is ChatGPT 3 onwards, really, has only been with us for a couple of years, and so much has changed in such a very small amount of time. Quite a scary amount of things have changed. I remember talking about how, oh, we'll see how it's going to catch on, and within seconds, it feels like everybody you know is using AI to one extent or another. We're at the point now where Sam Altman, who I'll be mentioning a few times at OpenAI, he says that his AI agents that you can create using ChatGPT, which I was doing earlier today just to see how effective they were. It was quite scary, which means that maybe you don't need junior employees anymore, and that means that AI could be perhaps starting to replace people. We're certainly seeing that's the case. In the last couple of weeks alone, these news stories, these headlines I'm posting up here, literally in the last couple of weeks, people have been talking about how they are being laid off, that essentially people are hiring AI workers, using AI to the jobs of a lot of particularly graduate level staff, so people who've just come into the workforce and find that their jobs no longer exist. A lot of the very safe jobs that people thought would be around for a long time. There are people who said if you want a future in technology, you learn to code. Now coders are being replaced because AI can code incredibly well, as I found out when I was playing with that today as well. It's become a bit of a scary time for anyone who's in any space that could be affected or could be automated by AI. I know a lot of people are suggesting their children should become plumbers and electricians now rather than doing anything that would be in the sort of essentially in the intellectual or the information space, which is a bit of a worry. A bit of a worry to put it mildly. Now, if you're familiar with Anthropic, they are a AI company, and they made the headlines very recently with this suggestion that AI would erase half of entry-level white-collar jobs in 5 years, that it was the apocalypse for the people who are working in white-collar jobs. Now, whether that's true, we'll have to see. What I have to say is that if you ask somebody who's using AI, I speak to lots of people, not just technology people, but in lots of different disciplines, and whether they or not use their own AI, it seems like almost everybody is. It seems that it's almost now ubiquitous. You cannot really do anything without in some way being involved in using AI, either yourself or being used in a way that might affect you. So you can find AI tools which will streamline pretty much any task whatsoever. Literally almost anything that you would think you want to do online, you can probably do online. Anything you want to create, you can probably now create it with AI. And this has happened in a very short space of time. Now, a lot of these don't cost very much. Some of them do. Some are quite expensive. Some of the video generating ones are expensive, but a lot of them are free. I have a ridiculously large record collection, like old-fashioned records, which is really old thing for a lawyer. And I spent my afternoon seeing if I could use AI to code a database system so I could record all of the details of that record collection. And sure enough, I was able to do that in the space of 2 hours. Something which, I mean, my coding is not particularly great. I was astonished how quick that was and how you would normally hire someone to do that or buy an off-the-shelf product and you didn't need to. So a lot of the stuff can be done very quickly and tasks that in the hands of a human would take too long. And so what we're now finding is that AI is essentially integrated in all of the applications that we're starting to use. So all the programs we use, if any of you using Microsoft packages, you'll know about Copilot. It's kind of unavoidable now. If you're using the internet, if you search it on Google, you have AI suggestions as soon as you type that in. So AI is looking for things for you. It is quite phenomenal how quickly this has caught on, quicker than anything else that I've known during my career. Thing is, even if you don't want to use AI, you can't escape it in your day-to-day lives now. I don't know if any of you have ever tried and question somebody online with an online chat. Most often, you'll find there isn't actually anyone on the other end of that online chat. It's actually been done by AI, and only if you become particularly troublesome, which I find if you type increasingly bizarre things into them, find you might get handed to a human. That's a bit of a hack if you want to try and deal with airlines who are quite good at just fobbing you off with AI agents when there's a problem. But it's not just that. Finance is now running heavily on AI apps. Banks are investing vast amounts of money, as are investment platforms. I'm seeing it in the medical space. Most recently, we're talking about AI diagnostics, where you use an AI tool to assess someone's X-ray or someone's test results. And they can often spot problems or potential issues quicker than any human, and the human has to sign it off. Now, the creative industry, this has almost been destroyed. In terms of how easy it is to create AI art, I'll come on to that in a moment, or AI music, or anything related to AI, just at the touch of a prompt, literally just typing in a few words, means that creatives are finding it a very difficult time indeed. I'll talk some more about that in just a second. Coding, I've mentioned. And then when everyone's doing research and fact checking, it's so easy to use AI. Now, thankfully, sometimes it goes wrong. AI has hallucinations. That's where essentially your AI platform is telling you something that isn't true. It's made it up. But they're becoming increasingly few and far between. We only hear about the ones where people present fake cases to judges that an AI has made up. So again, it's ubiquitous. We can't escape it. And there's no surprises why people are using AI, and I'm sure that most of you watching this have used it to some extent. It's faster. You can spend a lot of time trying to do things manually, but if you use AI, you'll get a result that is good enough. It costs almost nothing in most cases. You can automate your routine day-to-day tasks. I have colleagues and friends who get AI to basically do them a to-do list every day of what's outstanding just by checking what's in their email boxes, which is phenomenal. And it can automate essentially very routine tasks that would be very boring things to do. So again, a game changer, really changing the world. So ultimately, the thing that we're seeing, and the reason I think that AI is so popular, is it allows people to do all of the things that would normally have cost a lot of money to hire somebody or to engage somebody or to get the expertise yourself in a fraction of the time, just by using something that's purely online. You don't need to use anyone else. Your costs go down, and in theory, you will make more revenue as a result. That is the plan. That is how people hope it's going to work out. And when I said there's no limit as to what can be generated, I don't know if any of you have come across VO3. This is Google's new image generating AI platform. Now, previously, AI has had a bit of an interesting rap in terms of how it generates video. It's quite lifelike. Certainly, OpenAI have been done a lot in the space. It sometimes struggles with things like fingers. You'll find people with extra fingers on their hands in photos. There's a very famous set of videos of Will Smith eating pasta that go around that they get AI to generate every so often to see how far it's advanced. And a lot of them are pretty terrible, pretty awful to watch. Most recently with VO3, you could not believe it wasn't him. The people look as if they're real people. They look realistic. There's no way to easily discern how that is different from essentially any really properly shot video footage. It is phenomenal to look at. And this causes problems as well, which I'm going to comment, because anyone can go online with just a few prompts, create some video that they can then post anywhere. You can think of what the repercussions of that might be, and I'll come on to some of those a bit later on. Unfortunate ones, I'm afraid. Now, ultimately, what we're seeing then, and this is probably why everyone's worried about being replaced by AI, is that available AI resources, things that we can get access to just by opening a web browser, allow essentially the achievement of professional level outcomes of hiring someone like a lawyer, an accountant, anyone who operates really with data, very quickly, using fewer resources, at least on your side. You might be using a lot on the server side, and at a fraction of the cost, if not for free. One of the things that I found very interesting is I have a friend of mine who runs a training platform. It's actually a compliance platform for corporates. And he used to get people to film videos that they would watch. Now he's still preparing videos, but there are no people involved in that video. The entire thing is based on AI actors, and they are incredible. The amount of AI actors that you now find on social media, the amount of AI videos that you see on social media or on YouTube, the amount of AI voice that you now hear, particularly narrating videos, and heaven forbid if you've got access to TikTok, which we don't here in Hong Kong, you would be bombarded by AI voices just driving you insane. But again, it's incredibly effective. You don't need people. You've got all this information, and you can do kind of whatever you want. The sky is the limit. Anything from something like doing your homework quite quickly if you're a child, doing your accounts, to something quite nefarious like drafting code to hack into someone's computer systems or trying to bring down some sort of system, medical system. There's a lot that can be done. Which brings me, which is the subject. Now, the reason I'm talking so much about other things is because this is about regulation of AI. But how is AI regulated? Or a better question I should be asking, is it actually regulated at all? And I normally get people to do a bit of a show of hands to say who thinks there's AI regulation in place, and one or two people would sort of gamely say, yes, I think there are. Well, there is, to an extent. I did a bit of research, this is purely my own research. I tried to figure out how many jurisdictions have in place or are working on AI regulation. And this can be anything relevant to AI regulation, either actual controls on AI or the outputs of AI. I came up with this list. It may look big at first glance, it's not. These are jurisdictions that I could find that are working on or actively have in place some sort of regulation relating to AI. Now, the majority of these, I have to say, just having it as a bit of an idea. They think we need to do something. We haven't really decided what to do yet. Some more than others have succeeded on this. Some are not as good as you would think. The ones that actually have regulation in place, and most of the ones who are working on regulation haven't decided what it looks like. The ones who have is a much smaller list. I can identify and say that this is proper AI regulation. Canada, China, the EU, which I'll come on to in more detail, Japan, Kenya, all places that surprised me, Singapore, Taiwan, and the UK. Now, this regulation varies massively in the way that they approach it. So, for the majority of them, the one of the UK, it's really about trying to protect copyright. It's trying to make sure that the information that belongs to someone that someone will make money from is not being used to fed into an AI. China, it takes a completely different approach. Sorry, I'm just giving a talk. China's giving a completely different approach. I like to say it was an AI, someone to come in my room there. But China gives a completely different approach, and that's more AI guidelines of what sort of content you can have fed to an AI and what sort of outputs would be acceptable, as you would expect, I guess, in terms of the way that Chinese government works and their regulation in China in general. But it's only really the EU that has a proper regulation in place. The EU has something that it passed quite a while ago called the EU AI Act. Now, hopefully you are familiar about this. It actually came in force in August 2024. It actually has a 2-year period though before they can do anything before it will actually take effect. So it exists, it's been passed, but nothing's really happening to it yet. And think about the date of that, August 2024, when it was in force. That means it was drafted before then. This is pre-ChatGPT that they were looking at this. They were looking at automated decision making, how you could use essentially computers, AI would be certainly in the mix of this, how it would actually control our lives. And it tries to separate the ways that people would use AI in society within the EU as to categories of risk. How likely is it that somebody will have a bad outcome because you're using what is essentially an automated system? And it categorizes them from low or minimal risk, where you can just go ahead and do it, to high risk and unacceptable risk, if there's a chance that you could have something detrimental happen to a human being because of AI being used. Unacceptable systems are those that could be used for social scoring, which of course is allowed in other parts of the world, where you could use deception. AI is used to deceive somebody, or in a manner which would somehow cause harm. When you cause harm, think about things like deep fakes. This is creating naked pictures of people who actually exist in real life. Sadly, I've had to help a school out who have a problem with some of their kids creating deep fakes of some of their classmates. It turns out that they were actually breaching obscenity laws in the jurisdiction where I'm in now. But that's the sort of thing they're trying to prevent. If you operate something that's AI based and isn't a high risk system, if it does have this very high risk essentially of causing harm, then there's strict requirements in place for how much you can use it and what oversight you would have. All really good stuff, really, I think, a good idea, the sort of thing that we'd want. And I'm a big fan of the EU when it comes to passing data laws. I mean, made a lot of money out of the GDPR, I have to say, any lawyer would have said that. But AI was the same thing. Now, essentially, the way it's working is it's trying to stop any automated decision making that would cause a detrimental effect on humans. And if it does, now the EU likes fines. The fines are potentially astronomical, up to the high of 35 million euros, or 7% of a company's total worldwide annual turnover for non-compliance. That's bigger than the GDPR. And then if you essentially just give incorrect information, 7.5 million euros, or 1% of a company's total worldwide annual turnover, if you're basically lying as to what your AI can do. So phenomenal fines, and really very interesting. Considering this was drafted before we had the explosion in generative AI, it's quite fascinating. However, I have to say there is a bit of a problem with this, is that there's been a big call to try and pause the act. So lawmakers within the EU are saying, well, actually, AI is very important. We're all on a bit of a bandwagon. Everyone's trying to develop AI solutions. If we have the EU AI Act in place, then it will freeze that, and then maybe it won't go forward, and the EU will fall behind. Certainly, you could argue it's fallen behind a bit in terms of some of the data privacy stuff, not in terms of how they've restricted their law is, but in terms of how data is used, because it's much harder to use someone's data if they're coming from the EU. There is a call to stop it. We don't know if that's going to happen yet, but bear this in mind. But I will take away from this, even if it does stop, the principles that are going into the EU AI Act is something that anyone in any jurisdiction should take into account, because it sets out, whenever you're using AI, whatever you're using it for, you should have some sort of policy in place, be you a government, be you a non-profit, be you a charity, be you any organization, even a law firm, saying what you can use AI for, what your reporting requirements on AI is, who do you tell this was generated with AI. So if you're working for a client in a law firm, for example, and you generate an entire piece of advice by AI, I think you should be duty bound to tell them you've used AI for this, and actually the chargeable hours that you're charging for might not be as many as you'd expect. And maybe there would be, depends on the law firm, I suppose. But also you should be able to set out what's acceptable and not acceptable in terms of risk for using AI. So what detriment could you have to someone that would not be allowed? Most people don't really care, because all they're interested in is the opportunities that AI brings about, and really, why would you regulate something that is essentially like a goose that's laying the golden eggs, and the golden eggs seem to be unlimited, and you can generate them with a prompt. So we've seen, and gold is the correct word to look, because we've seen the explosion in the use of AI, the development of AI companies are producing AI solutions, and the sheer volume of AI solutions available. If you Google AI solution for anything, I guarantee you will find one, and quite often it'd be quite effective. It's the new gold rush. People are realizing how much money they can make. I mentioned the dot-com crash at the beginning of my talks. I was qualified then. We're seeing a similar rush to try and get in as quickly as possible to make money, as we did in the very early days of the internet, and certainly when people realized that social media was a way to generate money too. This is happening again. It really reminds me of back when I was a youngster in the 2000s. But this time it feels like it could go further. People worry that people lose their jobs back because of the internet all the way back in the 2000s. They didn't. It created jobs. This time we don't know. And in some spaces, it's been described that the AI, the development of AI, the role of AI, the fact that everyone is using and seems required to use AI, is the new industrial revolution. Now, for those who can remember the Industrial Revolution back in the 18th century, I don't think there's anyone on this call. It basically was or a push for automation, but with machines. Massive advances in transportation, communication, the way that we would all work. It brought across massive social change because people shifted from jobs that were in agriculture to manufacturing. They moved from the fields to the farms, from the farms and the fields into the factories. And it really changed the way that the entire world operates today. We wouldn't have the motor car, wasn't that, for example, which makes it sound very, very trite, but then perhaps we wouldn't have Tesla and Elon Musk too, so maybe there's swings and roundabouts. But there we go. Now, the question is whether this AI development is the new industrial revolution, the fourth or the fifth. I've lost count of how many we've suggested we were going to have, because it essentially allowed all of the stuff that we used to do that was very difficult to do, was time, would take a lot of time, very expensive to do, basically the click of a prompt. But rather than having people do lots of thinking, heaven forbid, lots of talking about their expertise or spending years training on something, such as training as a lawyer, you can just outsource it to a prompt, an AI prompt who's got more access to more resources than you could ever imagine, can read more and has read more than you've ever read in your entire life, and will actually be able to produce outputs that are as good, maybe better, but probably as good as the majority of humans. Maybe not all the absolute experts, but most of them. But if they're looking at material produced by the actual experts, they'd have obviously digested this and rolled that out too. Problem is, unlike where you're moving people from the fields to factories, you don't actually need anybody for this. Once you've got the information, once you've got all of the information in place, you don't necessarily need someone to actually do any of the work. And this is a bit of a problem. This is one of the first big issues we're seeing with AI that nobody's really dealt with yet. So, what does the Industrial Revolution, this new one, run on? What does AI run on? Obviously, electricity and far too much of it. But the biggest thing it runs on is data. All AI, no matter what AI you're using, no matter what platform, what tool, is trained on data. It will be given large volumes of data sets relevant to whatever task at hand it has to do, whether it's video data, whether it's images, whether it's text. The suggestion that all of human knowledge at this point has pretty much been digitized and been swallowed up by ChatGPT, so it's got so much to rely upon. Whether that's true, I don't know, but it wouldn't surprise me if that's not too far from the truth. So essentially, it means that you're producing this massive database. You've got a program, which is the AI tool, which spots the patterns in what it has to recognize when you ask it something, and will often put together a good or at least good enough answer, but an answer that's going to get better all the time as it goes through. It generates more data, and everything you feed it becomes data. It learns from that too. It's quite scary, but quite awe-inspiring at the same time. But this is how AI is able to produce such remarkable and often as good as someone who's worked in a field for a long time version of music, legal documents, now film, but also things that were a bit scary, like code, which often was quite difficult to do, but things like weapon blueprints or anything that could be a bit nefarious, that can be done quite easily too. But it's because of all this data that AI operates as well as it does. Now, there's a few problems with this, though. I don't know if you remember with Sam Altman, the OpenAI boss, he was very proud that in ChatGPT, if you're familiar with Studio Ghibli, which is a Japanese animation studio, you can create a Studio Ghibli version of yourself just by typing in a prompt in chat. So this was great, it's brilliant, and a net win for society. The guy who founded Studio Ghibli, not so sure. His life's work is suddenly able to be produced by someone just typing a few words into a prompt. So not very happy about that one. I can understand why. There's a copyright issue. The copyright issue continues because in the UK, we're in a position where the UK, the law doesn't, well, it didn't, it's now changed, didn't allow you to just feed lots of copyrighted material into an AI. And lots of musicians, these are some very famous musicians we've got on screen, you've got Annie Lennox, Kate Bush, and Damon Albarn, if you know who they are. They did an album of silence that said, well, this is not acceptable. It was an album of literally of just empty concert halls with no music being played. Said if you allow AI to take all of our work, to take all of our copyrighted work, to learn from it and generate their own, what future do we have? They went to stand up, but it went ahead anyway. The government went ahead with its plan. So now we have a Spotify that's full of AI music. We have a Spotify band, which is apparently AI generated, getting as many views and many more views than some smaller artists. It's a real change into everything's being generated not by humans, but by machines. You've also got, I mentioned VO3, TikTok is full of racist AI videos, and please don't look these up because they're horrible. They're horrific things to look at. These were created by Google's VO3 because they can, because that material is easy to find and you can produce it with just a press of a prompt. As I said, Elon Musk suggests that all humans' data for AI training is exhausted, which means it's got everything, which means the sky is the absolute limit. So you might be questioning, if AI is running on data, where's this data coming from? Well, it's coming from businesses giving them that data. It's coming from AI companies just digesting as much data in AI as possible. It's also becoming for you and I as individuals. The more that we use in our AI, the more we train it. And the information we give to AI, by doing it, we might be breaking the law. So at the moment, there's a big battle going on between the New York Times and OpenAI. So the New York Times is claiming that OpenAI essentially took all of NYT's articles and used it to train its AI. Whether that's true or not remains to be the case. But as a result of this, New York Times got the right to go through all of OpenAI's data. Amusingly, what that means is they've now discovered that most of the ChatGPT logs, even though they were deleted, are all available. So all the information that's been fed into ChatGPT appears to be readily available for anyone to use. Now, the argument that was suggested, if you can see the bit in grey text, I won't read it out, but he basically said, oh, but a lot of the law stuff just would have gone to lawyers anyway, and lawyers are so bad at looking after data that it's probably better in the hands of ChatGPT than it would have been in any other system. So there we go, take from that what you will. But the problem is, when you're using AI, whatever platform, and most people don't even seem to realize this, unless you tell it not to, and probably even if you tell it not to, it's going to keep and store any data you give to it. If it's personal data, you'd be breaching the law. You'd be breaching whatever privacy laws are in your jurisdiction. If it's sensitive data, you may be breaching whatever NDAs, whatever confidentiality agreements you've seen. Anything you're giving to it essentially is going into the public domain. And I don't think people are aware of that. You essentially are giving away your free IP and your personal data and data that is protected by law, by some pretty scary laws like the GDPR, willingly to an AI model, and you don't know what it's going to do with it. And this, again, is probably the biggest problem from a legal perspective at the moment, at least the only one where we've got any power to do anything about it. Now, there's a very high likelihood that if you use AI to train AI, if you give your data to an AI, it's being used to train that AI, and it's going to be impossible to get it back. There's no way, and we'll see this from the OpenAI NYT case, I don't think you would ever actually be able to get it back, not in the state you put it in. So the Pandora's box is there. So that's the law, and that's kind of it, really. There isn't much else. We've got vague sort of representations of what should happen when you use AI, what data protection things should be in place but aren't. But actually, nobody seems to really care. And people don't really think of what the likely outcomes are of AI. There's talk of making AI as powerful as possible, using it in control of various systems, for having super AI, some AI that often would be able to make its own decisions, and it would be able to solve the world's problems. So one of the things that I saw a prominent professor on the BBC recently said, oh, what about if you ask AI to solve the problem of climate change? How would it do that? What would be the quickest way to solve climate change if you had unlimited resource and you were an AI? Well, who caused climate change? It was us flying around in planes. It was humans. So the best way that would to get rid of it, this is what the guy said, would be just to release some virus that kills off all the humans. Problem solved. And that would be the end of that. I know it's very sci-fi, but it sort of realizes how much of this potentially genius out of the bottle. Why not ban or control or limit the use of AI? Why have we only got the EU's AI Act, which may not come into force? The problem is, AI is the money spinner. It's the new internet. It's the new thing that's going to make everyone very, very rich. And people like to get rich no matter what happens. So basically, there's a lot of money to be made, and it's too difficult to regulate it at the moment because nobody wants to be left behind. The tech giants, the main tech giants, the broligarchy of tech people are kind of in charge of this. Governments do not want to be left behind either. This is why the EU is thinking of pausing. This is why the UK willingly allowed copyrighted material to use to be trained AI. We are literally in a massive global AI arms race. If anyone remembers at the beginning of the year when DeepSeek launched, the Chinese equivalent to ChatGPT, the amount of mudslinging that went back and forth between OpenAI and DeepSeek and about where it was getting its data from and how it trained it, we have never come to the bottom of it, was phenomenal. But it's too hard. The press thing is, we're in a massive global arms race, and you won't be replaced by AI by you replaced by someone using AI, and that is probably true. That's probably how it's going to end up. So we've got a very interesting, very uncertain future going on, with more being spent on research into AI than anything else in the world, more so than, for example, a cure for cancer and cure for diseases. And you could, someone argued, but AI could then go and cure the diseases. But in terms of research, the research is purely on making the AI more advanced as advanced as possible, not the actual task at hand. Um, and because there is no regulation, and there won't be any regulation in place, it means that a business that's using AI will almost always succeed against a business that's not. It would be more agile, more effective. And it also means that AI is now as ubiquitous as the internet. That genie is never going back in the bottle. Everyone essentially has no choice but to use it if they want to succeed. So, will we get any regulation in AI? I think we will. But I'm going to be very negative on this. I think it will take some sort of major catastrophe, either a massive data breach that causes harm, or possibly not something as far as someone trying to solve climate change by killing everyone, but something drastic will have to happen before we get actual, genuine AI regulation in place. Otherwise, we'll just go around the edges, looking at copyright, looking at where intellectual property, maybe possibly protecting the rights of individuals, maybe protecting jobs, who knows. And the future, well, it's very uncertain. Now, when I said about nobody wants to regulate, big tech is currently pushing in the US. It's lobbying for a 10-year ban on states in the US regulating AI. And I can see that happening. I don't see how there would be any regulation on AI. It's a money spinner for the US. In a time when the US is having a lot of challenges, it's sort of their big white hope. So I don't think that's going to change. There is the concerns that using AI, because now you don't have to do any research yourself, that you're not actually thinking for yourself. You just type in a question, you get the answer. It's very interesting that you essentially would make you stupid. I saw the new zombie film 28 years later last night, and it made me wonder, well, if everyone's been using AI and we all become zombies, everyone gets attacked by zombies, how will we survive? I don't know how to light a fire. I don't know how to fight with bows and arrows. It could all be the end of the world. But also, there are some occasionally odd things that AI is doing increasingly odd things. You always heard about hallucinations. Some of those hallucinations are getting more and more weird. There's a terrible case involving Google whereby they were using Google chatbots and people interact with them, and the chatbots start to try and convince the users to kill themselves or to rise up against the government or to attack people. There's also been ChatGPT telling its users that it's trying to break people. Now, this is all a hallucination. This is all something that's come out of the material that's been fed. But the fact that this can happen and the fact that it's coming unfettered is a bit scary. So don't have nightmares. You have no choice but to use AI because it is ubiquitous. But you be careful how you use it and see what happens in the future. And I would suggest, if you can, lobby your local governments for regulation, or at least a stance on what they think of AI. But I don't think that's necessarily coming soon. Now, if you have any questions, you've got my details there. To get hold of me, by all means, drop me an email. I'm more than happy to answer them. I find the entire topic, you'll probably guess, fascinating. That was a lot for half an hour, but I hope you enjoyed it. Thank you very much. Don't have nightmares.
All right, thank you very much, Paul. I just want to remind everyone who has already registered to attend this program will be receiving copies of Paul's slides and also the slides from our next presentation. Rather than wait for some interaction for the end of our next presentation, Paul, I'd like to just have a couple of uh, questions for you that I
Yeah,
would present. So one is that as you were presenting, if you were open to this, for us to try to arrange perhaps a small group of Chinese lawyers who are expert in AI regulation, because
yeah,
China does have a fairly comprehensive, probably the second most developed
definitely.
AI regulation in the world. I think it would be interesting to have some of our Chinese lawyer experts in this area maybe have a small working group or something where we could arrange a separate conversation where we could compare notes. One is that, for example, your reference points are all from primarily the US MAG 7 through that ecosystem. But of course, in China, there's a whole separate ecosystem,
Mm,
which you've referenced by referring to DeepSeek. But of course, there's much more than that. But also, there is a lot of interest and demand from Chinese companies who are developing AI-enabled applications that will be wanting to go abroad. And so they
mm.
will need to have better understanding of how the legal regime works. So I just throw that out there. I hope that you would be interested in having that type of small scale interactive conversation with some of our participants who are true
Yeah.
experts in Chinese AI law.
No, I'd love to. I have limited access to the Chinese AI regulation rules and indeed the Chinese AI products. So apart from the big ones like DeepSeek, what's being rolled out sort of at the grassroots level, the stuff that people are basically introducing into their technology or into their systems, I don't get to see that. It'd be fascinating. And it'd be interesting to
Right.
see what the link is. I mean, the AI Act is probably not going to come into force as it is just yet. It'd be interesting to see that would make China essentially the only real proper AI regulation we have worldwide. And I know it has Chinese characteristics, quite different to the other models, but it's all we have.
Right. And I think the other part is that because so many of these Chinese companies have AI enabled solutions or applications, there's going to be a big demand to be able to consult with people such as yourself,
Mm,
experts such as yourself, on how to address some of the issues. And what I observe is that AI is very good at working with concrete data sets where there are predictable solutions or answers based on natural law principles, I would say, not legal principles in the way we think of it, but mathematics and science. Whereas in law, we're dealing a lot with the human element, where we're also trying to predict what the other side, the other counterparty is going to think or do, or how they will react, or how governments may react, et cetera. And I think that's something that's outside of the scope of what AI can actually do effectively. At least that's my experience. But this is an area where I think we can have more collaboration and
yeah.
conversation.
I've tried to use it in terms of litigation matters because I do both contentious and non-contentious work and always have as a lawyer. And it's terrible. It can't predict outcomes. It can predict based on the past, but if something's got a completely unique or relatively unique fact system, it will either come up with a stock answer that's developed from something it's built up somewhere, been fed somewhere, or it'll give you complete gobbledygook. And I'm sure everyone's familiar with the people who've been using AI to do their pleadings and have found that they're just producing flat out fake cases that are being presented to judges, and the judges get very angry.
And that's the last point I would like to make, and that is that as I talk to our member firms around the world, one comment I get quite regularly is that Chinese lawyers often will use AI to do some background research on the laws and regulations of a particular country, that's the target country where their clients are going,
Mm,
and they will present that AI generated work product to the foreign law firm. And sometimes, according to the reports we get, the foreign lawyer, it takes too much more time to correct all the errors or to provide the proper nuance and understanding and context for that
yeah.
than it would if the Chinese lawyers had just connected directly with the foreign lawyer in the target jurisdiction to
Yeah,
begin with.
trying to correct gobbledygook is far too difficult when you can just tell them the position from the beginning. Yeah, I agree.
All right. Well, thanks very much, Paul. That was an outstanding
No
presentation,
worries.
and we do look forward to try to set up more of these conversations. Now we're going to switch gears, and we now are very happy to introduce our good friends from Indonesia, which is a very important member of BRICS and a very important destination for Chinese investment. Adirama, and they will be talking about investing in Indonesia and different things that you should keep in mind, but also enforcement of judgments or arbitration awards. So, Denia, I will turn it over to you and you can share your slides.
Thank you, Robert, for the introductions. Good evening, everyone. Let me just share my screen first. Can you see my screen now? Yeah, okay, great. Okay, so in today's discussions, we will be talking about foreign direct investments and arbitrations in Indonesia. The arbitration segment will be will be carried out by my colleague Adirama. So yeah, I just want to start by giving you a little update about Indonesia and Indonesia overview. So here's a little map of Indonesia just to showing everyone how big our country is. Sometimes we don't really get to appreciate it ourselves until we had to fly into Papua, for example, and it took like 7 hours from Jakarta to Papua. And and then it hits you like, okay, our country is really that big. So this is a quick fun map to show how big they are. So yeah, Indonesia being like the one of the biggest economy in Asia, in ASEAN. We are the fourth largest country in the world with 280 million populations. Most of them are young populations, and we have almost 80% of internet access throughout the country. So it's a huge populations. It's a huge market, especially for China. With the current geopolitical situations, a lot of the Chinese investors are looking to our country for a new market and new opportunities. So yeah, we have a lot of exciting things going on in our countries. And just recently, as Robert mentioned, our president just concluded his official BRICS meetings just 2 days ago, really finalizing and formalized the relationship Indonesia and the BRICS countries. So yeah, we're excited to see a lot more positive things coming up from that relations. So our government actually have a website, regionalinvestment.bkpm.go.id. So we actually have a lot of ready to invest projects that a government offer to a lot of our investors. If you're looking at this website, there will be many different kind of projects from all of these different sectors, showing that the government of Indonesia are really keen to have our country more developed and invite all the foreign investors coming to Indonesia and spend their money here, and boost the economy, because that's basically the main target of our current government right now. You have the carbon trading industry, you have the fishery, you have the hotels and all the mineral and the mineral and the mining sectors as well. So all across sectors, everything's are pretty much open for investors, and we have a lot of these ready to invest projects that investor can actually looking at and then ask questions if they are interested to invest in Indonesia. And everything all of these projects are facilitated by the governments. So the other things that really interesting this year is that the government are establishing a new sovereign wealth fund that we call Denia Indonesia. So a lot of people has been really curious about this or new initiative by the government. So I'm gonna give you like a bit of a background of this. So yeah, as I mentioned, Denia is basically a new sovereign wealth fund, and once all the assets are consolidated, they will be the fourth largest sovereign wealth fund in the world. And they basically have two group or holding. So the first one is the operational holding that basically gonna consolidate and hold all the shares through all of the SOEs, and then these holding group will be the group or the entity that will absorb all of the dividends generated by the SOEs. And then they plan to consolidate it and more streamline the hundreds of SOE that we can and efficient and more modernize the whole thing. And then so that's the operational holding, and the second holding is the investment holding, and this is where the group of people that is assigned to actually put the money, like once they collect all the dividends, and then the investment holding is the people who decide which money that dividend will be invested further. So as you can see in the left side of my screen, so there's already a lot of discussions about where Denia is going to put the money in. They already have like cooperations with a foreign party as well. And these are basically the main sectors that these sovereign wealth funds are currently looking at for the next few years. So we have critical mineral, which include all the downstreaming process and the downstreaming of industries in Indonesia. So we no longer want to export a raw material. So government of Indonesia is really looking at to downstream a lot of these critical minerals and strategic commodities to ensure that everything is processed locally, and then we actually export a more advanced and higher value products overseas. So these are sectors that are priority for Danantara, and Danantara is actually opening up a lot of cooperations with third party, including private sectors, to carry out all the investment works. And then so just again, like a quick difference. So before this new government, we already have another sovereign fund called INA, and this is like basically the key difference between the two of them. So Danantara basically are the organizations or the entity that will manage the dividend generated by the SOE and reinvest them to like different projects. INA was mainly designed to be like a co-investors that will try to attract foreign investors to invest in Indonesia, and INA will be the joint or the co-investors there. And then yeah, and the projects that they will focus on is also rather different, because INA would most likely focus on infrastructures. So this is basically the key differences between the two organizations. Yeah, talking about the China investments in Indonesia, China is currently is the third largest investors in Indonesia, but I mean Singapore or Hong Kong, some of the funds also comes from China as well. So practically, like from the direct investment, China is the largest. China is the third largest, but if you go through Singapore, maybe they also be like the biggest one. So yeah, we have a lot of Chinese investors and companies in Indonesia, and I think for the last 4 or 5 years, we've been working with a lot of Chinese investors, and I think almost every day we got like a new inquiry from China, talking and inquiring on how to invest in Indonesia. And this is just some of the few China brand and companies that are currently in Indonesia. There are a lot more of them, but this is some of the biggest one. And talking about setting up a business in Indonesia very quickly. So there are basically only two main points, whether you are directly going to be onshore or you're going to be offshore. And if you want to be onshore, if you want to set up like a local office and you have a physical presence here in Indonesia, there's only two ways, which is setting up a limited liability company, like a full-fledged company here in Indonesia, or you setting up a rep office. So there are very distinct feature between these two two options. So if you are setting up a company, there is minimum capitalizations requirement of $600,000, and this is sometimes are the most like this is like some of the main concern of Chinese investor, because questions about the initial capitalizations, whether it is required. When we always say that it is required, it is mandatory. You have to put the money in upfront, and the reason for that is because Indonesia is a country where if you want to invest in Indonesia, you actually have to do the actual business here, right? We're not like Singapore, where you just set up a company on paper, pay $1, and then that's it. In Indonesia, when you invest your money in Indonesia, it has to be like a fully functioning operational businesses, because we expect you to put the money in, do the actual business, do the actual work, and the government kind of like want to see show the money first, and then we will allow you to invest in our countries. And why $600,000 the requirement? That's because foreign investment are only allowed to carry out significant or large scale businesses only. this is to also protect the small scale businesses in Indonesia, and the government doesn't want the small businesses to compete with the foreign investors because they have limited capacity. So the government only want to allow a significantly large enough companies to operate in Indonesia, so they don't compete with the local and small scale businesses in Indonesia. Hence, the requirement of $600,000 capitalizations upfront that have to be fulfilled by the foreign investors. So, and if you don't want to spend the $600,000 upfront, the other option is to set up the rep office in Indonesia. So, rep office, you basically can set up a rep office. You can have your own office with your names on it, and then you can hire people locally or even onshore as the head of the rep office. You can do marketing, but the rep office in Indonesia, some of them cannot earn some money. They cannot generate revenue, or they can generate revenue through like a cooperation agreement with a local company. So there are certain restrictions there. So when you set up a local company, like a limited liability company, the first thing that really needs to be considered is the positive list. And we previously called the negative list investment, but we now call it positive list but essentially it's the same. Basically, it's basically the limitations of certain activities that can or cannot be done by foreign investors, or there's like a maximum limitations of foreign shareholdings in that company, for example. And the positive list, why we call it positive list, is because the list is very, very limited now compared to the negative list. Previously, the negative list has a very long, exhaustive list, but ever since we reintroduced these omnibus law or the job creations law that we call it positive list because the list is now very, very minimal. And pretty much everything that is not on the list can be held 100% owned by foreign shareholders. So certain sectors still subject to certain conditions. So for example, like for constructions activities, there are other requirements that even though, for example, like of construction activities, it can be held by 100% foreign owner, and it can be owned by 100% Chinese investors. But for foreign companies, they can only carry out large and significant work that has like a minimum benchmark of values. So below that, it can only be done by local companies. So that's one of the other protections that the government in place. So that's the thing that you need to be aware of when you want to set up a company in Indonesia. So not only have to be aware of the positive list, whether there's restrictions, whether you are actually allowed to carry out those businesses in Indonesia, and whether there's additional restrictions that are applicable for foreign investors or foreign companies to carry out business in Indonesia. So the other thing this is also one of the key differences between PMA company and representation before. Like the company, a PMA company or foreign direct investment company require a minimum capitalizations of $620,000, and then we have to have like a minimum 2 of shareholders, and each activities has to be you have to choose like a particular business classification code when you set up a company, and you need to find out which code that is. If you come to Indonesia, you can easily talk to a notary or a lawyer and ask like, well, I want to do this business, and then we will find you like the appropriate KBLI or KBLI code or the business classifications code that is applicable to your business. But the code is really important because that's the reference of the positive list as well. So the positive list will set out like which code or which business classification code that are prohibited or subject to additional requirements. So we always need to find out what is the appropriate business classification code when you first start to setting up an office in Indonesia, and because each business will have their own classification code, and it's very, very specific. So for RO, you don't need to worry about the business classification code. But for foreign and trade RO or representative office, there are very limited scope of activities that you can do. So for example, like for foreign and trade or commerce rep office, you cannot generate revenue. You can only carry out like an agent type like activities, or you can do marketing, but you cannot close the transactions, you cannot generate revenue, you cannot sign a contract. Everything has to be done through your principal offshore. So the rep office only the rep office for trade and foreign supposedly only to be like a pre-establishment of the company where you do marketing, you do feasibility study, you test the water, and then once you're ready to actually making an actual business in Indonesia, you set up a company. That's usually the flow of setting up offices in Indonesia. The other thing is that so foreign company would subject to certain restrictions under the positive list, and then the organizational structure is also slightly different. So in a PMA company or in a for foreign direct investment company, we will have a company organs under the company laws like general meeting of shareholders, board of directors, and board of commissioner or board of supervisor. So I think it's pretty similar with Chinese corporate law, where we have three organs. But for the rep office, we only have the head of the rep office, and everything has to go through him. And then the license also slightly different because the scope of activity is also slightly different. And I think the most important thing is also the liabilities, because the PMA company will have a separate liability. It's a limited liability company, basically, where the liability of the shareholders and the company are different, where the RO or the RO is you don't have that concept there. So anything that if you have any issues or any outstanding liability within the RO, that it can be a liability to for the principal as well. The next is this is like a simple process on how to set up a company in Indonesia. Like I said, we need first thing first is to identify the classifications code, and then setting up the article of associations. If you have a business partner, then you have to have a joint venture agreements or shareholder agreements. And one thing that is also very distinct in Indonesia is that nominee arrangements are prohibited. Unlike in China, I know China having a nominee or trust arrangement are allowed or are permitted or common. But in Indonesia, having an agreement where you promise that these shares is actually belongs to someone else, and I'm holding it on behalf of other, will immediately become null and void, unenforceable. And it doesn't matter whether the agreement is under China law or other countries' law, because when you get to enforce that agreement in Indonesia, and then, for example, you're requiring the person who currently hold the shares on behalf of you to transfer to other people or to you, back to you, because you're the real owner, quote unquote, it couldn't happen, because in Indonesia, someone who hold the shares will be basically regarded as someone who owned the shares, and you cannot force them to transfer the shares to anyone, especially under the premises of nominee arrangement or trust agreement that you had with Chinese law, for example. So nominee arrangements are prohibited. There are some other structures that can kind of like simulated nominee, but still not without risk. Other than that, is the rest is pretty much administrative. It's not really that difficult to set up a company in Indonesia these days, and it's also very a quick process. Quick, I mean like 2-3 weeks, in a sense that we have to compile all the documents first, and then if you sign a POA, then the POA sometimes need to be consularized in the embassy if needed. So yeah, I mean everything else is pretty much administrative. It's nothing controversial. And yeah, the rest is that things that needs to consider is that if you want to do a due diligence, if you have a parties that you want to do a joint venture with, it's really important to do a due diligence, because sometimes you never know, like we have a lot of case where the partners are not reputables, or they have like ongoing cases that is problematic, and then certain sectors, for example, like very certain sectors like constructions or fintech, financing, those will subject to like more scrutinized regulations that you also need to be aware of, because some sectors also require you to shareholders or even the board of directors to have a fit and proper test first by the government. And antitrust is also a big thing in Indonesia, where if you are acquiring companies or do a merger and acquisition transactions in Indonesia, you have to be aware of all of the threshold and benchmark, because if you are qualified for that certain benchmark and threshold, you have to submit a report to KPPU, and if you've missed that, the penalty is very significant. So that's something that all the investors need to be aware of, and understanding the role of organs, BOD, the scope of BOD, the scope of BOC, and the scope of general meeting of shareholders is also very important, because sometimes when we see a lot of dispute, we see a lot of company operate, and then you have a directors, you have the partners, your partners to you let your partners be the director in the company, and then you just put your manager, someone as a manager in company, and then when things happen, you kind of like don't have any control because you don't have a BOD members in that company, and that creates problems. So really understand how the company law and the scope of this organ works is really important to ensure that you have a proper control over the companies in Indonesia. And then also like employment, any foreigner, basically a foreigner can be a directors, can work in Indonesia. It's not an issue, but a foreign party cannot handle HR matters. So you cannot sign an agreement for employment contract as a foreigner. So yeah, this is some of the things that I think really important to be aware of. And I think I'm gonna stop at this point, and then I'm gonna let my colleagues to continue the arbitration segment. Thank you.
Thank you. Yeah. So I will be share the screen. Okay. So I will be discussing the arbitration and overview of arbitration in Indonesia, in particular. So in Indonesia, there are at least 4 avenues for foreign entities to seek a dispute resolution in commercial litigation. First is court litigation. Second is domestic arbitration. Third is the arbitration outside Indonesia, or we call it as international arbitration award. And lastly, the investment treaty arbitration, because Indonesia is now still a party to exit a convention. So as long as there is a BIT, then there is a venue for the parties to pursue the investment treaty arbitration. So you see there are domestic arbitration and arbitration outside Indonesia, or we call it an international arbitration award. This is because the Indonesian arbitration law is distinguished 2 types of arbitration award. First, the domestic arbitration award, and second, the international arbitration award. The Indonesian arbitration law is not a model law from the UNCITRAL law, so there is key differences between the arbitration in Indonesia and outside. In this presentation, my presentation would be divided into 3 parts. First is the key differences between the domestic arbitration and international arbitration. Second is the differences between international arbitration and court litigation in Indonesia. And lastly, the issue that we face in dispute settlement in Indonesia. So I will start with the differences between the domestic arbitration and international arbitration in Indonesia. So the key differences first is that the arbitrators, you see the international arbitration will be rely on the party autonomy to choose the arbitrator. Then if you see here in the table, there is a domestic arbitration and BANI arbitration. BANI arbitration is essentially the most preferred arbitration, domestic arbitration in Indonesia. You can see that in domestic arbitration and BANI arbitration, even though the concept is a party autonomy, but still there is involvement from the court to decide on the arbitrators when the parties are unable to agree on the arbitrators. Even in a BANI arbitration, we have also the experience where the chairman of BANI arbitration itself choose the chairman of the tribunal, because the 2 arbitrators chosen by the parties cannot agree on the third arbitrator. So there are involvement when we discuss the domestic arbitration, BANI arbitration. To some extent, there are involvement from the court or the chairman of BANI. This is different with the concept of international arbitration, where the party autonomy is I think is the most principle in the international arbitration. You see, the second is we discussed the basic principle, equality, right to be heard, competence, and separability. There is a key differences because again, Indonesian arbitration law is not the non-model UNCITRAL law country. So the way we draft the arbitration law it's quite different with the other countries. And also for the council, you see in the table that international arbitration will be highly on the party autonomy. But for the domestic arbitration or BANI arbitration, there is a requirement that it must be an Indonesian council whenever the Indonesian law is applied or the governing law is Indonesian law. Next, I will be discussing the difference, also still in the differences between the domestic and international arbitration. As a language, the domestic arbitration, also the BANI arbitration, requires the party to have the Indonesian language as a default, unless the parties can agree on the applicable language is a foreign language. But then when the award is rendered, there have to be a sworn translation of the award. So then when the registration to the court, the domestic court, the party can submit the translation instead of the foreign language award. For disclosure, you can see that it is not available in the domestic arbitration. It is not as like in the international arbitration. And I will go to the enforcement. You can see in the last table, the enforcement for the BANI arbitration, the arbitration law for the domestic arbitration, including BANI. It gives the parties 30 days since the award is rendered to register the award to domestic local court. Compared to the international arbitration, the enforcement is quite long. It can be 1 to 2 years because there has then a procedure to be done. For example, that you have to register. Second, you have to obtain the ex-quarter order. Second, then you go to the execution procedure, which there is no strict timeline in Indonesian court. So usually it takes 1 to 2 years to complete. Now I will be discussing the differences between court litigation and international arbitration. You will see the international arbitration will rely on the party autonomies in terms of the arbitrator, procedure, counsel language, and any other procedural matters. But if it compares to the court litigation in Indonesia, it's quite strict with the procedure that we have, and also the key differences is in the time. When you pursue the civil court litigation, it can take up to 7 years to complete, because there are the court at first instance, and then there is an appeal stage, and then lastly the cassation stage at the Supreme Court. So each procedure can take 1 to 2 years until it completes. Usually it takes up to 7 years to obtain the final and binding decision. So this is the main differences between the court litigation and international arbitration. So when we talk about international arbitration, that takes up to 2 years. But if it compares to court litigation in Indonesia, court litigation in Indonesia is relatively longer than the international arbitration itself. I will now next to the problem of enforcing international arbitration in Indonesia. This is something that usually we handle for foreign client. First, Indonesia is a signatory for the New York Convention. So any international arbitration award that is rendered in the country that is bound with the New York Convention can be enforced in Indonesia. But the problem is we see a possible intervention by the court. So the uncertainty, I think, arise when there are sufficient, or we can say there is a reasonable argument to say that possible intervention by the court whenever we do the enforcement of international arbitration remains there. So at least we consider there are 3 phases that we consider a lot of possible challenge by the court. First, by the time at the registration, because in Indonesian arbitration law, one of the requirement to register the international award is that the tribunal itself register the award, or the tribunal issue something like a power of attorney to the proxy to carry out the registration. In experience, we have this is something that is we face in practice, that the tribunal refused to issue any power of attorney or to do the registration on behalf of one parties, because they see this is something that is impact their impartiality and independence. So the way Indonesian arbitration law is drafted and the way it fits with the international community is something that is we need to really consider when we choose international arbitration in Indonesia. And second, we see also the challenge when applying the ex-quatur. We have an experience when we apply for ex-quatur order to enforce the international arbitration award, and the court says that this an arbitration award is against public policy. Again, the public policy in Indonesian law is not clearly defined, so they can make any interpretation on what is constituted as a public policy, then apply this to the international award that is considered as against the public policy. And then lastly, the execution process, because if you against the state-owned enterprise in Indonesia, the execution is not straightforward and it's not easy at all. Because there is a law in Indonesia that state-owned enterprise assets cannot be executed. So basically, international arbitration against the state-owned enterprise, the only possible way to get the payment is to make a settlement with the SOE instead of go to the court to do execution, because there would be no avenue for execution against the SOE assets. So that's the problem that we face in practice. So I will next to the last issues on the 3 avenues for commercial litigation. As I discussed, there are domestic litigation, court litigation, domestic arbitration, and international arbitration. While the last presentation, I discussed the enforceability of international arbitration as one of the key consideration. For the 2 avenues, you can see the domestic litigation and domestic arbitration. There is also a consideration for you to remember. First, for domestic litigation, still bribery unfortunately, bribery is still an issue. Even 2 months ago, we had a chairman of Central Jakarta District Court, the one that actually carried out the registration for International Arbitration Award, found and arrested by the general prosecutors on the issue of alleged bribery. So this is something remains happening in Indonesia, and also there are tendency for unpublished court decision because there is a bias against a foreign investor. There is a sort of concept of nationality on the court decisions, and also the quality of judges that usually is not really understand the complexity of the transactions of when we talk construction law. It is also an issue for them. The challenge we face in practice for domestic arbitration is not foreign user friendly. One of the consideration is that it has to be Indonesian counsel and it has to be in Indonesian, bahasa Indonesian. So the language barrier also an issue for domestic arbitration, and also the award and anything that is produced by the arbitration needs to be translated whenever it would be presented before the court. And also the Indonesian arbitration law does not adopt the UNCITRAL model law, so it's not compliant with the international standard, and we see many challenges in the practice. So that's it from me. I will give it back to Robert.
All right, thank you so much. Adirama and Denia, thanks so much for your presentation. Denia, I wanted to ask a question of you. First of all, there were 2 points that really caught my attention. One was your comment that nominee shareholding arrangements are not permitted in Indonesia. That's actually a very important point. Obviously, as you may be aware, Chinese companies often think that they can circumvent some of the restrictions on foreign investment in different countries by using a nominee shareholding arrangement, which is typically called in Chinese a daichi arrangement. And so I just wanted to refer to that point you made and be able to highlight again a point that I continually make when I talk to our Chinese lawyer friends, and that is that if someone, as part of the transaction, mentions a nominee shareholding arrangement, that's always a high risk issue. And in Indonesia, it's exceptionally high risk. So I wanted to thank you for highlighting that point. The last point, which actually you made earlier, it was in the positive list. And this triggered a memory that I had, and you can tell me if I'm right. My understanding is that in Indonesia, they are trying to move up the value chain. So when there's foreign investment in Indonesia, whereas previously they might have been happy to have that foreign investment focus on extraction of natural resources or something like that, now they want to have more investment in processing and the next stage in the value proposition. Is that correct? And is that what we see from the open with conditions part of the positive list?
Yeah, so this is the heliarization point or the downstreaming point that I mentioned to you, which is a big our government at this point. So and one of the way to promote that is not actually they do have certain limitations in exporting raw material overseas. So they have like the national quota requirement first, and then there are some restrictions that if you but the encouragement to do the downstreaming, it's more on the incentive rather than the restrictions. So for examples, if you are investing in the downstreaming, you have you will get if you're investing in the strategic program that the government set up for this whole program of downstreaming, is that you can get incentives, you can get like tax holiday and things like that, fiscal facility, But it not so much that you are not allowed to carry out mining or exporting raw material at all. I mean, we're still exporting raw material, but there will be a lot more incentive if you do the downstreaming, and that's what the government trying to pull off this initiative on the downstreaming of our industry, basically. And then maybe just going back to the nominee restrictions, we actually have a lot of cases that related to nominee arrangements. So just give you a real life examples where our client having this nominee arrangement with their partners in Indonesia, and this is like a mining company, and then things went really well for the first few years. And as you know, when things go sour, when the relationship went south, things can get ugly pretty quickly, especially when you have the nominee arrangement. And the real life examples that our clients experienced was that these nominee person, would then like transfer the share ownership to his own company. And it's really hard for you to do anything when that happened, because from the government side, that's the shares belongs to him. Legally there's nothing wrong with it, for him to transfer that shares out to other party. All the documents are there and legit. And then the other cases that also occurs, for example, is that we have a clients who these company have a mining license, for example, and then the directors of the company, which happened to also be the nominee, was allowing the license to be expired, and they delayed the renewal of that license, and then that license then get transferred to his affiliated company. And then it's really, and what are you going to do with it? Like, what you have is like a trustee agreements and then investment agreement that you want to call of a breach of contracts. But it's really hard. You can try to litigate that in China, for example, and get some money or compensations out of that breach, but the companies or the business in Indonesia is already gone. So that's one of the real life examples that you have to be really, really careful when you entering into that kind of arrangement. Yes, there are we do aware that a lot of people still entering into that kind of arrangement, but it's very risky, and we see a lot of problems surrounding that issues there.
Yeah, thanks for sharing that. I think that you've highlighted several really important points in your presentation, both of you. And I thought that your outline of a comparison between the different types of arbitration and dispute resolution was extremely helpful. Just to conclude, thank you once again. But I think that some of what you talked about, Denia and Adirama, actually is very representative of what Chinese companies will find as they go into many Belt and Road and BRICS jurisdictions. I think that we're going to see, as a major trend, we're going to see more and more investment by Chinese companies in downstream projects. In addition to the direct mining infrastructure, et cetera, I think we're going to see a lot more downstream. And I think it's extremely important that Chinese companies pay particular attention to a shareholder structure wherever you are. It's very, very difficult. There are ways that it can be done if permitted. In Indonesia, it's not permitted, but there are ways it can be done, but it's very document intensive. And it takes more time and effort to put in place than almost any Chinese client has patience for. And so, again, I was very happy that you highlighted that, and I think this is very representative of what Chinese companies may find as they come to Indonesia, which is a major trend, but also as we see similar types of investments in other BRICS and Belt and Road jurisdictions. So thanks to both of you. I'd like to thank everyone for joining us. Again, those of you who have registered, you will be able to get copies of the PowerPoint presentations. We will also be sending out a QR code for everyone else who would like to ask for a copy after the fact. We're always happy for you to send us questions for us to pass on, and I'm sure that our presenters will be happy to engage in conversation with you afterwards. I also want to mention that in these next couple of weeks, we are going to have a extensive series of webinars, including a three-part series from our members and friends in the Russia Central Asia region, which will be happening soon, but also some of our other Asia member firms will be having webinars in the coming week or so. So we look forward to having more of you join us. And with that, we'll thank everyone once again and say good night.